Welcome back. This is the Act 4 and last of the depiction of common law history. Act 4 is taking us to North America, and more precisely to the United States. You see here North America in the 1700s, and these maps show actually that only part of North America was under English influence. The French were holding or controlling a sizable part of the continent, and so did the Spanish. You have here the English settlements that were stretching on thousands of miles along the East Coast. And we have to keep in mind that each colony was quite distant from the other. You had either to navigate or ride horses during days to go from one colony to the others. This map is showing the 13 colonies that have formed the United States after the Revolution, the War of Independence. The focus will be, in the first part of this presentation, on law in the English colony. We will discuss the law in the French colony in Louisiana in due course. The source is the chapter of the book that you have in the material discussing the establishment of the common law in the United States. And I will survey some of the colonies, almost all of them, starting with Massachusetts. The first legal text that we have of the 17th century, a resolution of 1636, or the Bodies of Liberties of 1641, insists on the word of God, or the law of God, to be applied in the absence of local statutes. However, you may see that whenever you wanted to convey land, it had to be done by deed, and that was done pretty much like in England. The common law was not mentioned in the legal text, but you find a few remnants, particularly in the terminology that was used in the colony. The forms of action, for example, were loosely followed in the courts. You have to wait for the 18th century to see judges trained as professional lawyers. Here you have a quote from John Adams saying that our ancestors were entitled to the common law of England when they emigrated. That is to say, to so much of it as they pleased to adopt and no more. That is an interesting thought. The colonists were thinking that they could refer to the common law as a birthright, but it should be adjusted to their present condition. Basically, it was their choice to decide what law to be applied to their new society. Connecticut followed a line similar to Massachusetts, with even more departure from the common law. Go to New Hampshire, you'll find that proceedings in the courts were in accordance with English law, and yet binding force was denied to any law that had not been enacted by the General Assembly of New Hampshire. Rhode Island codified its law. They had an extensive code departing in many ways from the common law. The common law was not recognized as binding unless it was said so in the code. The colony of New York is different. The reception of the common law has been rather complete in New York, and this is not surprising because of the bustling harbor and the bustling trade that existed between New York and England. However, there were few trained lawyers before 1700. They were having recourse to informal jury trials. A court of chancery was created in 1727, and an interesting document is a report sent to England by Governor Tyrone in 1774, shortly before independence. The common law of England, it says, is the fundamental law of the province. You see a very loyalist attitude in this statement. New Jersey favored a popular law administered by lay people. They didn't have lawyers and didn't care about lawyers. Early law was closer to the Bible than to the common law. Pennsylvania is a different story because it was entrusted to Penn by Charles II, and the charter signed by Charles II say that the law of property and criminal law should be the same as in England. They also had codes in Pennsylvania. Law was rather untechnical and was largely administered by laymen. Maryland favored local laws and usages, and by default, they would follow equity and good conscience. So pretty much a natural law spirit in the colony of Maryland. Let us now talk about the southern colonies, Virginia and the Carolinas. They had passed codes of law to make up for the absence of lawyers and law books. Now, it is an interesting phenomenon. In common law jurisdictions, you would resort to codification when you cannot have a full library of law reports, etc. In the English Empire, for example, India had resort to codification. The English government imposed the codification of the law of contract in India because the country was so large it was impossible to export their entire law libraries. As I am addressing the issue of documentation, there were very few law books in North America until the 1800s. The major book that circulated in North America was the Commentaries of the Law of England by William Blackstone. And this book has been quite influential. An example showing the departure from the common law was the law of succession. The Americans favored the division among the heirs in equal shares in the absence of a testament. There was a clear rejection of the English rule that the eldest son was to inherit the property. It makes sense to abandon or move away from these feudal traditions, and also think that land was plentiful in North America and there was no embarrassment in distributing or sharing land amongst the children. They could have easy access to more land if it was needed. So to wrap up on colonial law, to the law that existed prior to independence, it is largely popular and informal. Courts are typically staffed by laymen, and there were very few educated jurists. There was a tendency to be governed by a general sense of reason and justice. And also, you note a strong tendency towards codification, since a number of colonies arranged their laws in the form of a code. And this has been the case during the colonial period, but also after independence, as we will see in a moment with the New York Code of Civil Procedure. Property law was stripped from feudal tenures, and it's quite a remarkable factor. Property law in the US has kept some of the vocabulary and concept inherited from England, words like tenures, estates, that have a sort of feudal sound, but without society to be ever organized in a feudal manner. The United States will also favor the recordation of conveyances. Recordation of title has felt to be more important than it ever was in England. Comes the Declaration of Independence in 1776. And when you read the Declaration, you do not find there the words common law. The only reference to law is to the laws of nature. You have here the spirit of the Enlightenment that has been also dominating Europe at the same time, just before the age of codification. You have to come to the adoption of the Constitution to see here and there a few references to common law and equity. And you have seen these provisions in another video. It was clearly understood also after the time of independence that the common law, if applicable, was to be adjusted to local condition. You have here a statement by Judge Joseph Story. He said in a case in 1829 that the common law of England is not to be taken in all respects to be that of America. Our ancestors brought with them its general principles and claimed it as their birthright, but they brought with them and adopted only that portion which was applicable to their condition. So, some common law, yes, but provided that it matches the American spirit and life conditions in the New World. James Kent, who wrote in 1826 some commentaries on American law, a sort of American sequel to Blackstone's commentary on English law, also said that the common law, so far as it is applicable to our situation and government, has been recognized and adopted as one entire system by the constitutions of Massachusetts, New York, New Jersey, and Maryland. Interestingly, Kent insists on the adoption of the common law by some states. Clear reference was made to the applicability of the common law in their constitution. He goes on saying that it has been assumed by the courts of justice or declared by statutes with the like modification as the law of the land in every state. Now, is that true? It actually quite differs from what we know of the law in the colonies prior to independence. It is quite remarkable that the common law has been largely rejected as long as the colonies were under English control, and once they gain independence, they are here claiming that the common law is applicable. This is quite remarkable. But it seems that this preeminence of the common law is a sort of ex post facto phenomenon. And maybe it has been overstated or exaggeratedly stated in the writing of jurists like James Kent. It seems that the general adoption of the English common law is the new narrative of the 19th century, as you have seen with the quote of Kent. But it was not the case before independence. The common law, yes, had been used as an identity marker to contrast with the civil law. There was some insistence whenever they were fighting the French or the Spanish that we have habeas corpus, we have a superior system of law. So it seems that whenever suitable, reference would be made to the common law. But it clearly appears that all the new states, all the newcomers that will join the Union, with the exception of Louisiana, will adopt in their constitution the common law. Let us now address codification, because I said a little while ago that already before independence, there was a tendency or some willingness in some colonies to codify the law. And the experience of the state of New York, though it was the most common law state in the Union, is quite remarkable in this respect. And all this is due to a man, a pretty prominent lawyer named David Dudley Field. His life spans throughout almost the entire 19th century. Field had studied the codes of Louisiana. He was familiar with the Civil Code of 1825 and the Louisiana Code of Practice of 1825. And he has been drafting a code of civil procedure for the state of New York in 1850, which resembles significantly to the code of practice that existed in Louisiana. And this code of civil procedure has been a huge success, not only in the state of New York, but overall the United States. Most states, if not all of them, adopted a code of civil procedure and very often copied the Field Code. Field, who was a disciple of Jeremy Bentham, another apostle of codification, this time in England, Field tried to draft a civil code for the state of New York. And he had it published, he had the draft published in 1865. It was adopted in part, at least, by the legislature, but it was vetoed by the governor of the state of New York due to some political conflict that existed between Field and the governor. Maybe without this animosity between the two men, the great state of New York would have a civil code nowadays. And we have a clear idea of what it resembles, because this code not only is accessible in its draft, in its New York draft, but it has been inspiring codification in another state, no least than the state of California. California joined the Union and became a state in 1848. A choice had to be made as to the applicable law because, after all, California had been dominated by Spain and Mexico. Remarkably, the decision was not made by a legislature, but by the bar, by the assembly of lawyers practicing in the new state. And with an overwhelming majority, they decided to adopt the common law. The only part of the civil law that they have kept is the matrimonial regime of community of gains that is also applicable and retained in other Western states. This matrimonial regime, developed in the civil law tradition, was actually very favorable to women in a frontier society where women were largely contributing to developing the land, and it was only fair to give them the ownership of half the land that was left at the death of the husband. California went a step further. They decided to codify their law. They wanted something symbolic, something that had not been done in the other state. And there was a lot of word about the adoption of the Civil Code in 1872. This code was largely based on the New York draft made by David Dudley Field. You have here a few excerpts of the code. And in style, it very much resembles actually the French Civil Code. This is about contract. It is essential to the existence of the contract that there should be parties capable of contracting, their consent, a lawful object, and a sufficient cause or consideration. These words are remarkable because cause is a concept that you find in the French Civil Code. Consideration is the corresponding common law concept, and the two are connected with or in this sentence. Another provision is also very short and almost mimic an article that you could find in the Louisiana or in the French codes. A contract made expressly for the benefit of a third person may be enforced by him at any time before the parties thereto rescind it. The common law usually does not recognize that you may stipulate to the benefit of a third party. The civil law does. It's called the stipulation to the benefit of a third person. And this is actually copied from the Code of Louisiana. So you have this very, very interesting experience of a civil code that has a mix of common law and civil law language. Clearly, the style and the organization of the codes of France and Louisiana, the same divisions, book 1, person, book 2, things, book 3, the different means to acquire property. Let us look at the preliminary provisions, because very often the preliminary provision reveal a little bit the DNA of the code or of the codification project. The rules of constructions are quite remarkable. Article 4 says that the rule of the common law that statutes in derogation thereof are to be strictly construed has no application to this code. What does this say? We will see when studying statutory interpretation in the common law that the tradition is to interpret statutes strictly and narrowly. And this article says no application to this code. The code establishes the law of the state, respecting the subject to which it relates, and its provisions are to be liberally construed. Liberal interpretation, a little bit like exegesis, right? Or maybe the modern methods of interpretation that will soon emerge in Europe. And you see, in view to effect of its object, the spirit of the code, and to promote justice, the very purpose, the deep value or principle behind the law. So when you read Article 4, it seems to go or to invite judges in California to interpret their code like we would here in Louisiana, or like they would across the Atlantic in France, Italy, or Spain. But then you have a paragraph 5 that says that the provision of this code, so far as they are substantially the same as existing statutes or the common law, must be construed as continuations thereof and not as new enactments. This is a big limitation to this liberal spirit that is breathing in paragraph 4. And don't forget that the common law may be predominant in the state. If you can trace the rule to pre-existing statutes or to common law precedent, this is just a continuation of the common law. So when you look at this and try to identify the way forward, it is a little bit like this chaise that is pulled forward by a man and pulled backward by another man, okay? Is the way forward the common law and the way backward the civil law? I leave you decide, but you may guess that the answer is that the common law has won that battle. And this is due to one man, John Norton Pomeroy, who lived during a large part of the 19th century. He was born in 1828, and he had been made professor at the Hastings Law School in 1878, just 6 years after the adoption of the Civil Code. By the way, he was the only law professor in this law school. He was at the same time the dean and professor, and he had 200 students. Nonetheless, he found the time to write an article titled The True Method of Interpreting the Civil Code. And here he's giving his thoughts about the Civil Code of California. And when you read Pomeroy and have read his writing, he's very critical of the Civil Code. He thinks it is a wrong idea to have adopted a Civil Code or try to mimic the civil law tradition. And he is insisting, when educating his students or in his publications or in the speeches that he was giving to, at the Bar Council, that the code should be interpreted like a common law statute. So you may say that Pomeroy has killed any attempt, and there have been some attempts by earlier judges, to look at that code in a liberal way and give him the sort of interpretation that would prevail in a civil law jurisdiction. And you find a Pomeroy sequel in the code. Remarkably, the preliminary provisions have been revised in 1951, and here you have this amazing provision saying that the common law of England, you read with me, the common law of England is the rule of decision in all the courts of the state. Was California ever an English colony? Isn't it remarkable that in order to be in line and in harmony with the other state, they are making many years after the adoption of their civil code, that very strong statement that the common law of England is the rule of decision in all the courts of this state. I will leave you with this impression, and we reach now the end of the fourth act and of this series of 4 videos. I hope you enjoyed them,